5 seconds to go. Start. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court of Odisha at Cuttack in Land Acquisition Appeal number 79 of 2015, by which the High Court has dismissed the said appeal preferred by the appellant herein and has confirmed the order passed by the learned reference court. The original applicant has preferred the present appeal. The dispute is with respect to the apportionment of the amount of compensation with respect to the land acquired. The land originally stood recorded in the name of late Satya Negi, a common ancestor of the appellant and the other co-partners. The said Satya Negi died leaving behind his two sons, namely Chakradhar and Gajadhar. Chakradhar died leaving behind his four sons of late Satya Negi, the owner, and one daughter Kamala. Similarly, Gajadhar died leaving behind his two daughters, namely Kumari and Kumudini. With respect to the land acquired, Khasra number 81, Kop Singha, which originally stood recorded in the name of late Satya Negi, the amount of compensation was settled at rupees 6 lakhs in favor of the respondent numbers 2 to 5. At the instance of the appellant, claiming to be the daughter of Chakradhar and claiming 1/5 share in the amount of compensation, a reference was made to the reference code under section 30 of the Land Acquisition Act. The reference code, the learned civil judge Sundargarh rejected the claim of the appellant in the compensation mainly on the ground that as the parties belong to scheduled tribe community, the provisions of the Hindu Succession Act shall not be applicable, and therefore the appellant, being a daughter, shall not be entitled to the share in the amount of compensation. The order passed by the learned reference court denying the share in the amount of compensation has been confirmed by the High Court by the impugned judgment and order. Hence, the present appeal against the impugned judgment and order passed by the High Court. Learned counsel appearing on behalf of the appellant has heavily relied upon the decision of this court in the case of Madhu Kishwar and others versus State of Bihar in support of his submission that the appellant, being a daughter, shall be entitled to the share in the amount of compensation, even applying the provisions of the Hindu Succession Act. It is vehemently submitted that as observed and held by this court, it is submitted that as observed and held by this court, exclusive succession in the male line of heirs must remain in suspended animation till the immediate female relatives of the last male tenant continue to depend their livelihood on the land. It is submitted that as observed and held by this court in the aforesaid decision to deny the equal right to the woman daughter belonging to scheduled tribe would be gender-based discrimination, and the daughter cannot be denied the right in the joint family property in which all co-partners have the equal share. Making the above submissions and relying upon above decision, it is prayed to allow the present appeal and to hold that the appellant, being daughter of one of the co-partners, shall be entitled to 1/5 share in the amount of compensation. Present appeal is vehemently opposed by the learned counsel appearing on behalf of the contesting respondents. It is submitted that in the present case, the parties are members of the scheduled tribe. The suit land belongs to one Satyanegi, and after his death, the said land devolved upon his two sons, with the right of survivorship being available. The said person not passed away in the year 1948 before the commencement of Constitution of India and the Hindu Succession Act 1954. That after the death of Chakradhar and his wife, his share in the property stood devolved upon his four sons, who held 1/4 share each by way of succession. After more than 60 years of such succession, by the four sons holding 1/4 shares each, their properties were acquired by the government for establishment of ultra mega power project. The compensation for the acquisition of land was determined, and the same was duly paid to the four sons respondents herein, being the owner of the property. It is submitted that thereafter the appellant herein filed an application before the LAO claiming their 1/5 share in the compensation, being one of the descendants of the Satyanegi, that the matter was referred to the court of Senior Civil Judge Sundargarh in a matter of reference under section 30 of the Land Acquisition Act made by the Special Land Acquisition Officer. The learned reference court dismissed the application by holding that she is not entitled to claim any amount in the amount of compensation, as being member of the scheduled tribe. The provisions of Hindu Succession Act shall not be applicable, and therefore she would not have any right of survivorship in the joint family property. It is submitted that, considering the provisions, the High Court has not committed any error. Stop.